Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay? And basically we are discussing upon the writs, okay? And so far the writs that we have covered is the habeas corpus, mandamus, prohibition, and certiorari. Okay, so these are the writs that we have covered so far. So before starting this lecture, I will ask you the simple question. What is prescribed or meaning of the writs? Okay. What is prescribed or meaning of the writs? So you have the options like habeas corpus. Second is mandamus. Third is prohibition. Fourth is certiorari. Okay. Now you have 40 seconds to think and answer. Then I will give you the answer. Your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40. The time's up. So basically, if we talk about the habeas corpus, so it is a meaning of to have a body. Okay. If we talk about mandamus, so the meaning is we command. If we talk about prohibition, to stop something. If we talk about the certiorari, so to certify it or to authenticate. Okay, so that is the meaning. All right, so these are the writs that we have covered so far. So basically we will start from where we had left in the previous lecture. So basically we were discussing the certiorari writ, okay, which literal sense is to be certified or to be informed. All right, so basically this issued by the high court or to a lower court, high court to a lower court tribunal, okay, for checking the pending case and to squash the case. Okay, and this could be issued on the grounds of access jurisdiction, lack of jurisdiction, or error of law while passing the jurisdiction. Okay, and unlike the prohibition, which is only preventive, certiorari is both the preventive as well as the curative. All right. if we talk about the one aspect that we left in the previous lecture is that previously, if we talk about the writ of certiorari, okay, so it could be issued only against the judicial and the quasi-judicial authorities and not against the administrative authorities. Why? Because they do not having any judicial aspect. So because of this, they were out of the jurisdiction. But then comes the year 1991 when the Supreme Court held that the certiorari can be issued even against the administrative authority affecting the rights of individual. Like it means that doesn't matter whether the authority having the judicial aspect or not, but if it has taken any action due to which there is a violation of fundamental rights. Okay. All right. So this is the case when the certiorari could be issued even against the administrative authorities, which were previously exempted from the aspect of it. So now, like the prohibition, certiorari is also not available against the legislative bodies and the private bodies or other bodies, but the administrative authorities are now comes under the certiorari scope. Got it? Thereafter, the last writ we have is the quo warranto. Okay. So if we look at the literal sense of it, so it means by what authority or warrant? Okay. By what authority or warrant? What does it mean? It means that basically it asking for the cause of action, like something which happened. Now it's a time to check out that why, through which authority or through which warrant that thing was happened. So it is issued by the court to inquire into the legality of claim of a person to a public office. Okay. Hence, it prevents illegal usurpation of a public office by a person. Like you can say when there is a public office, all right, and there is a person who claimed the office, all right, and you can say there is a person whose fundamental right violated because of the claim of the office by someone. So the court could issue the writ of quo warranto, all right, so that the court could ask like through which authority or through which warrant you have done this. Okay. So you can say the writ can be issued only in case of a substantive public office of a permanent character created by the statute or by the constitution. Okay. It means that whenever there is a case of public office which had been either created by the statutory force, it means that by passing the separate act and rule regulations, and if by the constitution, it means that constitutional body. Okay, that's the thing. It cannot be issued in case of ministerial office or a private office. All right. Unlike the other four writs, this can be sought by any interest person and not necessarily by the aggrieved person. Okay. It means that if we talk about all the previous, so there was a case of violation of fundamental rights, right? Which means that there is a violation of the fundamental rights, and only the person whom fundamental rights were violated, that person could only apply to the court. But if we talk about this one, which means the certiorari, quo warranto. So basically in quo warranto, this is not necessary the person whose fundamental rights have been got violated, that person only could apply to the code. It is not necessary. Any interested person in this case can apply to the code. Okay, and the court will take the consideration of it and may be reserved the warranto. Thereafter, the power to make laws under Article 33 is conferred only on the Parliament and not on the state legislatures. Okay, okay. So here we have finished the rights, and now we are going to talk about the armed forces and the fundamental rights. Okay, so basically there is an Article 33 of the Indian Constitution which deals with it, and the power to make the any law regarding this is vested with the Parliament, not with the state legislature, to ensure the uniformity in actions throughout the country. All right. Any such law made by the Parliament cannot be challenged in any court on the grounds of contravention of any fundamental rights. It means that if there is any person who is serving in the armed forces, okay, and the person, due to the legislation passed by the Parliament, feels that his or her fundamental rights are getting violated, so the person could not apply to the court like any other ordinary citizen. All right. So anything passed by any resolution passed by the Parliament under the Article 33 could not be challenged in any court. Accordingly, the Parliament had enacted the Army Act 1950, Navy Act 1950, Air Force Act 1950, Police Forces Restrictions of Rights Act 1966, Border Security Force Act, and so on. Okay, which means that if there is any union armed forces, if we talk about them, so basically they having the category like first is the Indian Armed Forces. Okay, and these are four, like the Indian Army, like the Indian Air Force, like the Indian Navy, like the Indian Coast Guards. Okay, thereafter, the second division is for the Central Armed Police Forces. Okay, and these are five in number. Okay, like Central Industrial Security Force. Okay, like Central Reserve Police Force. Okay, like Border Security Force. Okay, like Indo-Tibetan. Let me write down again. Indo Tibetan Border Police. Okay, and Sashastra Seema Bal. Okay, thereafter the Civil Police. Okay, and then comes the various paramilitary forces. Notable examples are Assam Rifles, National Security Guards, and all. All right. So this is the case. So if you look at here, all these forces are the armed forces of Union. So if any personnel serving here, all right, whether in the Indian Army, Air Force, Navy, Coast Guards, or in the Central Industrial Security Force, Central Reserve Police Force, Border Security Force, Indo-Tibetan Border Police, or Special Seema Bal, or any civil force, civil police force, or you can say any paramilitary forces like the Assam Rifles and the National Security Guards, if they are serving here, so basically under the Article 33 of the Indian Constitution, their fundamental rights could be, you can say, restricted by the parliament. All right. And no such act could be hampered in any court by challenging it. So these impose the restrictions on their freedom of speech, their right to form associations, right to be members of trade unions, political associations, right to communicate with press, right to attend public meetings or demonstration, etc. Okay. All these rights were restricted and controlled by the government. Why? Because these forces are the pillars of national securities. Okay. So that's why it's become very much essential that we ensure whatever they are disclosing through the freedom of speech, whatever they are doing through the forming of associations, whatever they are doing to be the members of trade unions, political associations, what they are communicating to the press, and what they are doing while attending the public meetings or the demonstrations, all these things would be checked. That's why there is a rules. Thereafter, if we talk about this table, so this table basically compares the martial law with the national emergency. Okay, like both of the laws or both of the things, basically you can say implemented while there is a condition of extraordinary circumstances. Okay, whenever there is a condition of extraordinary circumstances, the martial law and the national emergency would be inclined. So if we talk about the common thing we had discussed, now this is the difference. What is the difference between the national emergency and how it differs from the martial law? So first is the martial law. The martial law affects only the fundamental rights. Okay, it means the fundamental rights will be suspended whenever there is a martial law in force. While if we talk about the national emergency, affects not only the fundamental rights but also the center-state relations, distribution of revenues, and the legislative powers between the center and the states, and may extend the tenure of the parliament. Okay, so you can say not only the fundamental rights they are affecting, but even the other aspects of the normal governance would be affected by that. Thereafter, it suspends the government and ordinary law courts. Okay, whenever the martial law will be in the forces, will be in the force, so all the powers of the government and the ordinary law courts would be granted to the armed forces. But when we talk about the national emergency, so basically it continues the government and the ordinary law courts. It does not suspend them. Thereafter, if we talk about the martial law, it is imposed to restore the breakdown of law and order due to any reason. But if we talk about the national emergency, so it could be imposed only on the three grounds: if there is a war, if there is an external aggregation, and if there is an armed rebellion. Okay, so only on these two grounds the national emergency could be imposed. While if we talk about the martial law, then it could be ensured on any reason through which the breakdown of law would happen. All right. Thereafter, it is imposed in some specific area of the country. like the area in which law and order was broken. Okay. If we talk about the national emergency, it is imposed either in the whole country or any part of it. Okay. It means that the imposition area is wider than the martial law. Thereafter, if we talk about the martial law, so we know it has no specific provision in the constitution. Okay. It is implicit. Okay. Like if we talk about the martial law, so you can say nothing is more, you can say nothing is more elaborated about the martial law. But when we talk about the national emergency, so basically it is very, very specific and well detailed provision in the constitution, and thus it is explicit. Okay, so that's a difference. Thereafter, if we talk about it, the expression members of the armed forces also covers such employees of the armed forces like who are the barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors, and who are non-combatants. All right, like the word armed forces basically gives the implication towards the combatants. Okay, but in reality, even the non-combatants, if they have the connection with the armed forces, if they have the connection with the armed forces, they would be considered as a member of armed forces. Thereafter, a parliamentary law enacted under Article 33 can also exclude the court-martial tribunal established under the military law from the writ jurisdiction of the Supreme Court and the High Court so far as the enforcement of fundamental right is concerned. All right, this is the thing, because if we talk about the armed forces tribunal or the tribunals established by the military law for the military and the paramilitary forces, so basically these are tribunals. And if we look at this picture, then we will find out that tribunals are generally the ordinary courts, or you can say lower courts in the judicial hierarchy. So that's why the higher courts like the Supreme Court and the High Court having the power to issue the writs. All right. So if the tribunal has passed any decision against anyone who is a member of armed forces, so the Supreme Court and the High Court could not issue the writs for the enforcement of the fundamental rights in that cases, and you can say the tribunal would be exempted from the jurisdictional scope. Thereafter, there is an Article 34. This provides for the restrictions on the fundamental rights while martial law is in the force in any area within the territory of India. Okay, so you can say Article 34 gives the blow to the martial law. Like whenever the martial law will be in the force, fundamental rights would be suspended. Empowers the parliament to indemnify any government servant or any other person of any act done by him in connection with the maintenance or restoration of order in any area, whether the martial law was in the force. It means that instead of the courts, the parliament will get the power to indemnify whether the government servant who got posted to any area where the martial law was in the force and whatsoever act he has done was according to the law or not. Okay, the parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under the martial law in such area. The act of indemnity made by the parliament cannot be challenged any court on the grounds of contravention of any of the fundamental rights. Okay, so if we talk about the martial law, so basically the concept of martial law has been borrowed in India from the English common law. Okay, however, the expression of martial law has not been defined anywhere in the constitution. Okay, there is only the Article 34. which was mentioned in the Constitution. All right. So if we look at from this picture, what we will see that this is the borrowed provision. All right. This is the thing. So we can say literally it means military law. Okay. It refers to a situation where the civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary rules. Okay. Because the condition is extraordinary. All right. So it does imply the suspension of ordinary rule, law, and the government by the military tribunals. Okay. It is different from the military law that is applicable to the armed forces. All right. Because that was applicable to the governance. Thereafter, we can see there is also no specific or express provision in the Constitution that authorizes the executive to declare the martial law. However, it is implicit in the Article 34, under which the martial law can be declared in any area within the territory of India. All right. It means the executive by itself could not declare the martial law. All right, because there is no specific or express provision in the Constitution of India. That is basically depends upon the power of Article 34, okay, which declared the martial law in any area within the territory of India. So, the martial law is imposed under the extraordinary circumstances, which are not the normal circumstances, like the case of war, invasion, insurrection, rebellion, riot, or any other resistance to the general law. Its justification is to repel force by force for maintaining or restoring order in the society. All right. During the operation of martial law, the military authorities are vested with the abnormal powers to take all necessary steps. Why? Because the philosophy is force by force. Okay. So basically that's why the abnormal powers, or you can say technically the abnormal force granted to the, you can say, military authorities. They impose restrictions and the regulations on the rights of civilians, can punish the civilians, and even condemn them to the death. It means that even the two rights (20 and 21) is not applicable during the cases of martial law. The declaration of martial law under Article 34 is different from the declaration of national emergency under the Article 352. The differences between the two is summarized in this table and we will see it. Alright. So students, basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.